New York City employers, are you ready for 2026? The City Council just passed sweeping changes to the Earned Safe and Sick Time Act. Starting February 22, 2026, employees can take leave for more reasons and you'll have to provide new unpaid time. Let's break down what this means. On September 25, 2025, the New York City Council approved amendments to the Earned Safe and Sick Time Act and repealed the separate Temporary Schedule Change Act. Changes take effect February 22, 2026. The goal is to broaden employee protections and simplify the rules by integrating schedule change rights into one law. Under the amendments, employees may use safe and sick time for several new reasons. First, caregiving. Employees can provide care for a child or a care recipient. Second, attending legal proceedings to apply for or maintain subsistence benefits or housing. Third, responding to a public disaster, for example, when a workplace is closed or a child's school shuts down due to severe weather. And fourth, dealing with workplace violence, meeting with legal or social service providers after a workplace incident. Beyond existing paid leave, you'll need to provide 32 hours of unpaid safe and sick time each year. This allotment must be available as soon as an employee is hired and then front-loaded annually on either the work anniversary or at the beginning of the calendar year. Employers must track paid and unpaid balances separately, adding a new layer of record keeping. The amendments repeal the separate Temporary Schedule Change Act, but its core protections survive. Employees will still be able to take time off for short-term personal events, now through the integrated ESSTA. This consolidation means one framework for short-term absences. The legislation also introduces 20 hours of paid prenatal leave each year for employees covered by ESSTA. This aligns with New York State's existing requirement, so the practical impact will be modest. Still, employers should ensure their policies reflect this entitlement. With less than a year before the effective date, employers need to act. Review and update policies to include new qualifying reasons and unpaid time. Reconfigure HR and payroll systems to track paid and unpaid balances. Train managers and HR staff on the expanded rights and how to handle requests. Update employee notices once the Department of Consumer and Worker Protections issues revised forms. And coordinate state and city compliance. Remember, the New York State paid sick leave law still applies statewide. Acting now will help avoid penalties and confusion once the amendments take effect. These changes constitute some of the most sweeping updates to New York City's leave laws in several years. Though they apply only within the 5 boroughs, the New York State Legislature often follows the city's lead. To summarize, New York City is expanding safe and sick time, adding new unpaid leave, new qualifying reasons, and integrating schedule change rights. Employers should prepare now. For tailored guidance and more updates on New York employment law, visit HortonPLLC.com, sign up for our newsletter, and follow Horton Law on LinkedIn. We're here to help you navigate these changes.